Hello everyone and welcome to the second of our video tutorials on duress. Today we're going to look at duress of circumstances. In our last video we looked at the defence of duress by threats, and if you recall, duress by threats is where the defendant was ordered to commit an offence while subject to threats of immediate death or serious personal violence that were so great as to overbear the ordinary powers of human resistance. Today, we're going to look at duress by circumstances. And duress of circumstances arises where it is not a person that provides a threat to the defendant, but the nature of the situation. And it might be that another person creates the threatening situation, but unlike duress by threats, there's no requirement that a person specifies to the defendant that a particular crime must be committed. So as long as there's a sufficient link between the situation and the crime, the defendant can have the defence. Look at this diagram then, this illustrates this. So for the defence of duress, we've got duress by threats, which we looked at last time, and duress of circumstances. And you can see that they're very similar because duress by threats is where the defendant is threatened with death or serious injury unless they commit a particular crime. Whereas duress of circumstances, our defendant is threatened with death or serious injury by a situation or a particular set of circumstances. Now, because these are so similar, they're largely governed by the same criteria. So all the rules on duress of threats will still apply to duress by circumstances. But the key similarity is that we still need a fear of death or serious injury. And as I've already said, with circumstances, it is the particular situation that dictates the crime rather than a particular threat being used. And for that reason, duress of circumstances has mainly been used as a defence to driving offences where the defendant felt compelled, well, they didn't have any choice but to commit a driving offence because of the circumstances they found themselves in, rather than having been threatened to do so. So, for example, if I'm in my car and there's a man with a gun and I'm thinking, oh no, he's going to shoot me, I might commit an offence driving on the pavement in order to escape him. In that situation, he obviously didn't threaten me. He didn't say, drive on the pavement or else I'll kill you. But the circumstances, him looking like he's going to shoot me unless I drive on the pavement, have forced me to commit that offence. Defence of duress of circumstances came about largely as a mistake in the case of R. and Willer, in which the defendant actually raised the defence of necessity. But the Court of Appeal allowed his appeal and stated in this case that he should have used the defence of duress of circumstances because he'd not been told to commit a crime, rather the threat came from the circumstances themselves. The facts of this case were that the appellant had been convicted of reckless driving originally. He'd driven up a narrow road and was confronted with a gang of shouting and brawling youths, and he heard one of them shouting, "I'll kill you, Willer," and another threatening to kill his passenger. He stopped and tried to turn the car around, but the youths surrounded him and they banged on the car, so the appellant mounted the pavement in order to escape. And of course, that's a criminal offence, it's reckless driving, and the trial judge ruled that he was guilty of reckless driving because the defence of necessity was not available. Our appellant appealed against the trial judge's ruling, and his conviction was quashed. And you can see here that the Court of Appeal held that the defence of duress should have been available to him, duress of circumstances, that is. See here the link between duress of circumstances and the defence of necessity, which we will look at in our next video tutorial. And what we will see is the defence of necessity is very restrictive. So it seems as though the defence of duress of circumstances developed because it's very difficult to plead necessity unless you're a medical professional. So this was recognising that he felt compelled, he had no other choice but to commit this criminal offence. The case of Willer set a precedent which was later followed in the case of Conway, where the Court of Appeal noted that there was no threat in Willer, but recognised the existence of this new defence and named it duress of circumstances. Facts of Conway were that the appellant was driving with a passenger, Mr. Tonner, in his car. Tonner had been in a vehicle a few weeks earlier when another man was shot and severely injured, and Tonner was chased and narrowly escaped. Tonner had been the intended victim of the shooting. The appellant noticed that a car was following him and, fearing that it was the person responsible for the shooting 2 weeks earlier, drove off at great speed and recklessly. In fact, the car was driven by 2 plainclothes policemen. The trial judge ruled that the defence of necessity could not be raised, and the appellant was convicted of reckless driving, and he appealed. And once again, the Court of Appeal quashed the conviction and said that the defence of duress of circumstances could be allowed because the defendant had acted in order to avoid a threat of death or serious injury. And once again, you can see here, just like in the case of Willer, the defence of necessity was not available in Willer, it wasn't available in Conway, but instead, the court is finding a solution by saying that it is the circumstances which forced the defendant to commit the crime. The case of Martin affirmed the defence of duress of circumstances and held that it was governed by the same rules as duress by threats. Of Martin were that the appellant had driven whilst disqualified from driving, and he claimed that he did so because his wife had threatened to commit suicide if he didn't drive their son to work. His wife had attempted suicide on previous occasions, and the son was late for work, and she feared he would lose his job if her husband didn't get him to work. The appellant pleaded guilty to driving whilst disqualified following a ruling by the trial judge that the defence of necessity was not available, and he appealed the ruling. And once again, his appeal was allowed. The defence of duress of circumstances should have been available to him, following the decisions in Conway and following the decision in Willer. And there was no distinction between driving whilst disqualified and reckless driving. And it also didn't matter that the threat of death arose through suicide rather than murder. And you can see that this case is saying that the same rules as duress of threat should apply. Duress of circumstances should use the same subjective and objective test in Graham and Howe in order for the defence to work. What we've seen here is that our 3 cases on duress of circumstances all involve cases where the defendant has committed an offence of a driving offence, So they're all used for a similar sort of situation, and you can see that although there's been no threat, there was an implied threat, I suppose, of death or serious injury. Let's summarise the defence of duress then. Not just duress of circumstances, which we've just been looking at, but let's just quickly remind ourselves of duress by threats. So for the topic of duress, you need to know duress by threats, and that's the most important one, to be honest with you. But you also have to know about duress of circumstances as well, and this links closely to the defence of necessity, which we'll be looking at in our next video. Reminder of duress by threats then, we started by looking at Graham, which gave us a 2-part test for the defence of duress, where firstly, there was a subjective limb. The defendant must have reasonable belief that death or serious injury would result if he didn't comply with the threat, and an objective limb, a sober person of reasonable firmness sharing the characteristics of the defendant might have acted as the defendant did. We then had a number of limitations added on the defence of duress, starting with seriousness of the threats. In Valderrama Vega, we saw that threats to reveal sensitive information alone are insufficient to raise the defence of duress, but they may be taken into account if accompanied by threats of death or serious personal violence. Nexus means that the threatener must specify the crime, so the threat must be accompanied by an order to commit a specified crime. It's not sufficient that the defendant has felt the need to commit a crime to meet a demand for money, say. You've got to have the threatener say, rob the bank or else I'll kill Seb. Okay, if they just say repay my money or I'll kill Seb, they haven't specified the crime, so that would be insufficient. There must be an unavoidable threat, so there must be a threat of immediate death or serious injury. That's the situation we're in following the case of Hassan, which followed the earlier case of Gill. Remember, Hudson and Taylor and Abdul Hussein took a more lenient approach to unavoidable threat, and they were looking at, was the threat still hanging over the defendant? But following the key case of Hassan, now it's got to be immediate. And if there's any opportunity to call the police, the defence will fail. We have the restriction of self-induced duress, and this is where we're saying that the defendant has brought it on themselves. So if the defendant voluntarily, with knowledge of its nature, joins a violent criminal gang, if that violent gang then turns on them and threatens them to commit an offence, they won't be allowed to have the defence of duress. And that comes again from the case of Hassan. Restriction is murder and attempted murder. We know that the defence of duress is not available to murder. That comes from Howe. It also isn't available for attempted murder, and that comes from Gotts. And this situation is the same regardless of the defendant's age, and that rather unfair rule comes from Wilson. So duress by threats is quite difficult to plead. You can see that there by the test and also all of the limitations. And then in today's tutorial, we've been looking at duress of circumstances, which we've seen is where the defendant commits a crime, although they've not been given a verbal threat, the circumstances make them feel compelled or forced into committing a crime in order to avoid death or serious personal injury. And there is quite a close link between duress of circumstances and necessity. As I've said, this situation, this defence, seems to have developed because of how restrictive necessity is. So that's something you could talk about if you were asked to do an evaluative essay on duress and necessity, that because necessity is so restrictive, we've developed this situation. So please watch the next video tutorial in which we will be looking at the defence of necessity.